Welcome. Thank you for being here on a Saturday morning to engage in this conversation about civility in political discourse in Vermont. My name is Bob Paolini. I'm the Executive Director of the Vermont Bar Association. I'm one of a committee of about 4 people that put this program together. I'll give you just 30 seconds of background, a couple of logistics, and then we'll start our program. This program is part of a national dialogue entitled Civility and Free Expression in a Constitutional Democracy. It's a program that was created jointly by the American Bar Association and the National Endowment for the Humanities. They put out grants proposals in, I think, early 2012, maybe even late 2011. And Vermont and the Vermont Bar Association was lucky enough to be one of 9 host states or sites to take part in this conversation. And I asked some colleagues to come together and form a planning committee to figure out, okay, now what do we do? And that planning committee contained Kevin Ryan, who many of you know is in the back of the room. He's the Director of Education and Communication at the Bar Association. Patricia Gable, who is the Deputy Court Administrator and General Counsel to the Vermont Judiciary, and Peter Gilbert, the Executive Director of the Vermont Humanities Council. So the 4 of us came together, and there were different topics, different focus topics that could be selected as part of these national conversations. There was a topic of civility and free expression in cyberspace, in popular culture, in the public square, or in the political world. We chose the political world. And thanks to the efforts of Chris Graff, we have, I think, a great panel that will have a conversation amongst themselves, and then I'm sure Chris will tell us all how we will all engage. As you know, we're going to start off with the keynote speaker later. And Peter Gilbert, who knows our keynote speaker very well, is going to introduce him to us. Peter is right there.
Good morning. It's a real honor and a privilege to introduce our keynote speaker this morning. The different chapters of Jim Leach's distinguished career have all been in one way or another related to our topic for this morning: civility, public discourse, democracy, and diplomacy. He was nominated by President Obama to be chairman of the National Endowment for the Humanities in 2009 in July. He was approved by the Senate, confirmed by the Senate the next month, and he served in that role until less than a month ago. Under his leadership, the NEH created the Bridging Cultures program, designed to promote civility, understanding, and mutual respect among diverse groups within the United States and abroad. His hard work and passionate commitment to the humanities, our civic culture, and our democratic society has earned him the respect and admiration of thousands who worked with him both in Washington and around the country. Immediately prior to his appointment to the NEH, he was a visiting professor of public and international affairs at the Woodrow Wilson School at Princeton. He was also interim director of the Institute of Politics at the Kennedy School of Government at Harvard. And for 30 years, from 1977 to 2007, he was a Republican member of the United States House of Representatives, representing Iowa's 2nd Congressional District. He was chair of the House Committee on Banking and Financial Services and a senior member of the House Committee on International Relations. Last but not least, he founded and co-chaired the Congressional Humanities Caucus. A graduate of Princeton, he received a master's in Soviet politics from the Johns Hopkins University and did additional graduate work at the London School of Economics. Before going to Congress, he was a member of the Foreign Service. It is Chairman Leach, thank you for, where is he? Where is he? There he is. I wanted to thank you for your service to our nation, especially for coming up to Vermont this morning to talk with us about this immensely important topic. Ladies and gentlemen, please join me in welcoming a man of great intelligence and thoughtfulness, decency and civility, Jim Leach.
Well, thank you, Peter. As many of you know, Peter is the head of the Vermont Humanities Council, and frankly, nationwide is considered the preeminent leader of a state council, and I'm honored to be with you, Peter. It's my intent this morning first to make a few observations about civility and its relevance to American governance, and then comment on how this subject relates to each of the three branches of our government. And in this process, I'd like to put in context the oaths public officials take and conclude with a challenge to the legal profession. Few subjects seem duller than concern for public manners. But in the context of American history, where change was wrought in the crucible of debate about the nature as well as the rights of man, little is more important for the world's leading democracy than recommitting to an ethos of thoughtfulness in the public square. The concept of civility implies politeness, but civil discourse is about more than good etiquette. At its core, civility requires respectful engagement, a willingness to consider other views and place them in the context of history and life experiences. Words matter. They reflect emotion as well as meaning. They clarify or cloud thought and energize action, sometimes bringing out the better angels of our nature, sometimes baser instincts. Stirring anger, for example, can play on irrational fears. Conversely, just as demagoguery can jeopardize social cohesion and even public safety, healing language, such as Lincoln's plea in the second inaugural for malice towards none and charity for all, can uplift and help bring society together. But civility isn't exclusively about governance. At issue is whether we perceive ourselves as belonging to a single American community with all its variety, and whether we look at people in other neighborhoods and other parts of the world as members of families seeking security and opportunity for their families just as we do our own. Nevertheless, in politics as in family, vigorous advocacy should never be considered a thing to be avoided. Argumentation is a social good. Indeed, it's a prerequisite to blocking tyranny and avoiding dogmatism. Rather than policing language, the goal should be to uplift the tenor and tone of debate and infuse it with historical and philosophical perspectives. The founders of American were moral philosophers as well as political activists. They affirmed a trinity of natural rights, which we all understand: life, liberty, pursuit of happiness. Precepts derived from two Enlightenment thinkers, the Englishman John Locke and a Swiss philosopher named Jean-Jacques Burlamaqui. These natural rights adherents applied to political theory an analytical framework analogous to the trinity of natural laws laid out by Sir Isaac Newton in the natural sciences. Just as Newton had studied the geophysical nature of motion, the founders dwelled on the nature of man. Hence, to protect against abusive authority, characteristic of feudal hierarchies, they established a constitutional framework designed to divide rather than concentrate power. They understood, as Madison pointed out in the 55th Federalist Papers, that just as there is a degree of depravity in mankind which requires a certain degree of circumspection and distrust, so there are other qualities in human nature which justify a certain portion of esteem and confidence. Republican governance, Madison emphasized, presupposes the existence of these qualities in a higher degree than any other form. In a parallel observation on human nature, I want to report on a difference between natural law and social behavior that I observed some years ago on the House floor. You may recall that Newton's third law of motion is that for every action there is an equal and opposite reaction. Human nature sometimes operates differently. Watching one afternoon the reaction of my colleagues on the other side of the aisle to a blistering partisan critique by the leader of my party, it became clear to me that in human dynamics, unlike natural laws of physics, reaction can sometimes be greater than action. I punningly label this phenomenon a Newtonian law, which is a corollary to Sir Isaac Newton's immutable laws, one which distinguishes human behavior from natural physics. When individuals, groups, or nations are described as in a pejorative manner, divisive feelings are stoked. The likelihood is that rhetorical reaction with potential actionable dimensions will escalate. In this era of overreaction, this observation has relevance at the dinner table, in local communities, national politics, and most consequentially, international relations. It is no accident that geostrategic thinkers have for generations raised the issue of face and warned against backing adversaries into a corner where mutual accommodation becomes impossible. In today's political context, let me mention three particularly troubling words: fascism, communism, and secession. Critics used to glibly refer to our former president, George W. Bush, as a fascist. Our current president, Barack Obama, has been called a fascist and a communist, sometimes at the same time. And since this past fall's election, hundreds of thousands of Americans have signed petitions sent to the White House suggesting that secession may be a credible, legitimate option. Well, what's wrong with this kind of political hyperbole? Plenty. These words that historically have contained warring implications. They infused political dialogue with an enemy as opposed to rival attitudes, yet the last thing America needs is to war against ourselves. Which brings me to the oath and its constitutional context. In the oath taken by our parliamentary ancestors in Great Britain, allegiance to the crown was affirmed. The essence of the oath American officials must take is of a very different nature. It is to support and defend the Constitution of the United States against all enemies, foreign and domestic, and to faithfully discharge the duties of office. Well, what does allegiance to the Constitution rather than the head of the state entail? The Constitution establishes a sovereign basis for the rule of law in a governing arrangement where power is divided and individual rights enumerated. These enumerated rights were not all-encompassing at the beginning of the Republic. People of color, those without property, and women were left out. It took most of a century to rectify the Constitution's sanctioning of slavery, and most of another one to make citizenship rights meaningful for all. When Lincoln signed the Emancipation Proclamation 10 years and 5 months ago, his clear intent was to make America truer to the ideals expressed in the Declaration of Independence. Trumpeted in the midst of war, the president also conceived and advanced the proclamation for practical political advantage. He wanted to rally abolitionist critics who had been pressing him to be more definitive about the values for which the Union stood, and he wanted to keep Britain and France, which had already abolished slavery, from supporting the Confederacy. I mention the international dimension of the Emancipation Proclamation because the implicit assumption of the founders was that the American model of constitutional governance was designed to be the most effective as well as humane manner of organizing public decision-making ever created. Today, we're challenged by legitimate concerns about national security, fiscal imbalance, and how best to incentivize job creation. These challenges are compounded by political ruptures that make decision-making based on mutual respect irascibly difficult. The world is watching. Unless we get our politics in order, the perceived magic of the American way could unravel before our eyes, and America's global leadership could become challenged, if not jeopardized. These are contentious times, but we have had testier moments in our history. The first decade of the 19th century saw Thomas Jefferson hire a journalist who described his presidential opponent, John Adams, as a hermaphrodite. 4 years later, our greatest Secretary of the Treasury, Alexander Hamilton, was shot dead in a duel with the Vice President of the United States, Aaron Burr, the triggering cause being Hamilton's assertion that Burr was despicable, which, by the way, the duel proved to be valid. And in the decades preceding the Civil War, Congressman Preston Brooks of South Carolina strode onto the Senate floor where he almost caned to death Senator Charles Sumner, an abolitionist from Massachusetts, for describing a senator who happened to be Brooks' uncle as, and I quote, a pimp for slavery. Democracy requires civil discourse in civil matters, but civility itself is not about staid politeness. Spirited advocacy energizes deliberations in public policy. Listening is important as speaking. Everybody can learn from somebody else. Seldom, after all, is there only one proper path determinable by one individual or one political party. Public decision-making doesn't lend itself to certitude, and that's why humility is a valued character trait and why partisan intransigence is rarely a worthy strategy in a constitutional democracy. The taking of an oath to support and defend the Constitution and faithfully discharge the duties of office is to recognize that process is our most important product. Government of, by, and for the people requires respectful give and take with an understanding that we are all connected and rely on each other. Governance is a shared responsibility. If all men are created equal, it follows that every individual deserves respect and that decision-making should be enhanced by a diversity of thought rather than shackled by partisan homogeneity. The power of negation, by contrast, leads to dysfunctionality, and it jeopardizes the national interest. As Lincoln warned in words borrowed from Scripture, a house divided cannot stand. Historically, all leaders in the executive branch call for bipartisanship, by which they presumptuously mean that others should go along with their views and their policies. I am as uncomfortable as anyone with the current state of executive-legislative relations, but I do not share the view that dissent is by its nature always unconstructive. Bipartisanship should be viewed in ways far beyond majority-minority relations. It is inevitable that in an increasingly complex society, political issues will become increasingly complex. Hence, it's inconceivable that citizens will be able to agree on every formal issue stand taken by one party or the other. Legitimate bipartisanship should respect internal dissent and expect occasional support from members of the other political party. Political parties, both majority and minority, have an obligation in a legislative setting to examine critically all policy initiatives and to oversee executive governance. We have today, for instance, what appears to be legitimate concerns being reflected about a government agency, in this case the IRS, that ignored the law in its treatment of a class of nonprofit organization called 501c4s. By the way, a category most American citizens have never heard of. Those who may have failed to live up to their constitutional responsibilities in the executive branch should be held accountable. Likewise, failure to review the merits of law designed, in this case, to authorize indirect, non-transparent, wealth-centric public financing of elections would be a dereliction of duty within the legislative branch. As money conflicts have multiplied, ideological cleavages intensified, the will and capacity of representatives of the people to mediate social differences is breaking down. Compromise may have once been the art of politics, but intransigence is the new art of political survival. If a legislator in today's environment chooses to seek common ground on an issue, i.e. compromise, he or she becomes vulnerable to a primary challenge where participation is low and money games are unforgiving. Why is this? When I left the Congress, I began teaching, and I developed about 45 to 50 courses, what I call 2-minute courses in American society, about American society, and I'm going to give you 3 or 4 real quick ones here. One I call Political Science 101, and it is mathematical. The country over the last generation has been about a third Democratic, a third Republican, and a third no party. Well, if you divide a third in half, if you're mathematical, you know that that's 1/6. So 1/6 of the American people control the Democratic Party, 1/6 the Republican, in terms of both choice of candidates as well as direction of a party platform. But in legislative circumstances, at most in general, 1 in 4 participate, and often it's 1 in 8 or 1 in 12. And what that means, again, if one's mathematical, 1/4 times 1/6 is 1/24. So about 4% of the American people control the Republican Party, about 4% the Democratic Party. Who are they? And I will tell you, in the Republican Party, it's been consistent in a sense. It's largely conservative, but the definition of conservative has changed. For those of you that have gotten a little gray, as I have, when I entered politics, conservative meant Barry Goldwater. Today, Barry Goldwater would be a left-wing Republican. Conservative today is basically a much greater social conservative. Barry was pro-choice and pro-gay rights, which would put him out of step with the new conservatives. The Democratic Party has been more consistent. It's been basically a stable, rather liberal part of American society. But the interesting phenomenon relates to something a little different, what I call political science 102. Everybody in America kind of understands that there are 2 candidates running for president, and one on the Republican side will probably move to right in a primary to get a nomination, and then in the general election tries to scoot a bit to the center. And it's the obverse on the Democratic side. But in legislative races, the first part of that remains valid. To get a nomination on the Republican side, one has to move pretty far to the right. But there's no scoot to the center. And the reason there isn't is that in legislative races, where the participation is so small, that if a candidate moves to the center or agrees to work with someone of the opposite political party in legislation, it's immediately noted, and that candidate will instantly get a primary challenge. And that primary challenge will be very well financed, often from outsiders, and outsiders in ways that the country has never thought about. And that is, our founders talked about every part of American democracy being represented by people who would reflect the views of their area. And so your Congress or your and analogously state legislators would be filled with people that represented a sector of that society. But now with money in politics, all local elections are nationalized, and people become indebted to the same groups. And sometimes, as I'll mention later, the same groups support both political parties in some instances. The 2 other courses I want to mention, well, 3 other I'll mention quickly. One I call Sports 101. When I entered politics, I used to make analogies between sports and politics, and there are certain ones that exist. By the time I left politics, it dawned on me that those analogies had virtually all broken down. That sports has a surprisingly higher ethic than American politics. And this is the case because they're referees. It's the case because there's no school system, no university president that will hire a coach who teaches kids not to respect their opponents. But in football, you have flags thrown for clips. In basketball, referees call fouls. In wrestling, which is America's preeminent sport, I'm from the state of Iowa, you get penalized for stalling. But people in sports have a higher ethic, even though we all know some of the egos that have caused problems, than the political system, where the analogy to a coach is a political consultant, and there is no political consultant that goes into a campaign that doesn't tell a candidate anything except to get elected you have to go negative. And that is a very bizarre aspect of American politics, radically different than the sports ethic. I have a course called Literature 101, which relates to something that existed particularly when I was a college student. There was a set of books that were very fashionable at the time called the Alexandria Quartet by a British author named Lawrence Durrell. And I'm not going to go into the books, but I'll mention this, that this British author wrote 4 books set in interwar, that is between World War I and World War II, Egypt, about a very minor set of events. And each book was titled by with an individual's name, and each book was a first-person narrative. But the incredible thing was that each book was about the exact same set of events, and you wonder, why do you read about the same thing 4 different times? And the implicit literary moral was that to understand reality, one has to look at something from 4 different sets of eyes. And if you think about that from let's say, a lawyer's point of view, that's kind of what occurs on a daily basis in courtrooms, that 2 people can make exactly the opposite contentions about exactly the same set of circumstances. And it isn't that one of the 2 people is lying, it's just how they see things. And so when you take political life, or international affairs in particular, it's helpful to look at things from different perspectives to get a sense of what's really the case. I'll just conclude with one other course, or in my course setting at least, and this I call Humanities 101, and it relates to the greatest political poem in the English language is probably Yeats's The Second Coming, when he talked about that the sinner cannot hold when the best lack all conviction and the worst are full of passionate intensity. And Yeats was writing about basically the trench warfare of World War I. But those kind of words have, unfortunately, a certain kind of resonance in many aspects of politics today. Well, anyway, civility, I'd like to stress again, is not simply or principally about manners. And for instance, on Capitol Hill, polite words are often more troubling than raucous ones. And let me give an example. If you take the Congress, unlike a state legislature, where in state legislatures people sit in the chambers most of the day, in Congress they sit frequently in the chamber, but they're walking back and forth between office buildings. And between office buildings there are always people standing around, very well dressed and well heeled and very polite, who are called lobbyists. And the number of times a member will be walking, or a senator, back and forth to the floor, someone will come up and say, Joe, sure glad to see you. We, as you know, we maxed out for you in the last campaign, hope to in the next, but we have this bill coming up tomorrow, and we'd sure appreciate your support. And by the way, how's your wife and kids? And this is a very polite conversation, but it is implicitly coercive, and it implies particularly that there's an ongoing contractual relationship between an elected official and a lobbyist. And this is very awkward, and these implicit uncivil contracts, even if never discussed, can be quite coercive, and they're newly magnified by one of the Supreme Court's, in my view, gravest historical errors, which is the 2010 Citizens United decision. On the assumption, for instance, that politicians have an instinct for political survival, a key component of which is a desire to raise campaign revenues and to deprive opponents of same, why in a corporate political system would a politician want to speak up against the drug companies or gambling interests or oil companies if corporate monies can be quickly shoveled into campaigns? Over our history, the court has been at the forefront of advancing justice and protecting the rule of law. But from time to time, our politics and the court have been out of step with our deepest ideals. For almost 9 decades, the court, for instance, supported slavery, and brazenly, and they're the worst ruling, and I suspect for all, maybe not for all time, but quite possibly for all time. Its greatest mistake was its Dred Scott decision, when it said, in effect, that individual human beings of a given kind could be bought and sold. But in Citizens United, there is a parallel logic with a syllogism that is inverted from Dred Scott. And Dred Scott held that to justify slavery, people could be considered private property. But to magnify corporate power a century and a half later, the court defined a class of private property called corporations as human beings, that is, as individuals with rights. And ironies abound. Despite evidence to the contrary, the mid-19th century court court could see no oppression in an institution that allowed individuals to be sold. In the Citizens United ruling, despite overwhelming evidence to the contrary, the court implied that corporations were somehow oppressed, in this case considered to be censored, and therefore should be freed to buy political influence and sell opposing candidates. To advance this logic, that First Amendment rights applied to corporations, and that more money in campaigns equates to more democracy, the court had to employ a linguistic gyration. It presumed that money is speech and that corporations are like individuals. But where in any dictionary does this concept hold? To believe that a corporation is a person with citizenship rights simply doesn't square with the Declaration of Independence. All men may be created equal in relation to each other, but not necessarily in relation to corporations or under Citizens United in relation to how corporations may empower some individuals relative to others. There's great inequality between corporations, no equality of individual and corporate personhood, and no equality of individuals when one with many corporate ties may have more capacity to influence decision-making than one with none or just a few. Corporate larceny is also at issue. To presume that corporate money can be construed as speech, that speech for many will be coerced rather than free. After all, to tap for political purposes the assets of shareholders, or by implication union members, more than a few of whom can be expected to hold different political judgments than management or union stewards, is a taking of their assets, a perversion of their speech, a diminution of their political rights. There's simply no escaping the reality that the precept of corporate personhood pushes American politics in an oligarchic direction, nor is there escaping the only justification for spending corporate assets in campaigns. Money spent in campaigns must be considered a good investment for shareholders, quid pro quos that can be banked. Could it be that the court's definition of protected speech might more accurately be described as influence buying? Prior to Citizens United, the Supreme Court implicitly recognized that citizen expression was different than issue advocacy backed by money. Hence, it upheld congressionally established reporting requirements and limits on campaign giving for individuals making campaign contributions. However, in Citizens United, corporate persons are granted supraman status, limited transparency requirements, and unlimited capacity to spew money in the political process. The court's lawmaking judgment cannot be challenged by Congress because an activist majority has presumptuously held that moneyed intervention capacities that it has granted corporations in the political process are protected by the First Amendment, and lacking an evidentiary basis and appreciation for human nature, the majority concluded that independent corporate political expenditures do not rise to corruption or the appearance of corruption. Really. And I say this, just think, there was one candidate in the last election that is reported to have received at least $22 million from one individual. Well, can any of you in this room be allowed under the law, if you had $22 million, to make a contribution to an individual? And the answer is you would go to jail. But by creating a corporation, that corporation can do that. And it's a preposterous way for law to operate. And in my view, it's rather self-evident that it's a great challenge to American democracy and our heritage. And the principal issue is not which political party most benefits, because the irony is that corporate power often operates with one troubling bipartisan dimension. Not all bipartisanship is good. And that is this: corporations have a tendency to align with those in either party who hold positions that may affect issues of direct concern to their interest. And what this means is that in a legislative session or a legislative context, Citizens United has the effect of increasing the likelihood that financial interest will increase their donations to both sides of banking-oriented committees, commodity groups to both sides of the Agricultural Committee, the military-industrial complex to both sides of the Armed Services Committee. Ideology has its place, but power in the commercial sphere supports power in the political domain, and that has nothing to do with the national interest. It's no accident that our tax laws are loaded with loopholes, that corporate muggings are frequent, nor is it an accident that many Americans, from Tea Party advocates to middle-class homeowners to the Occupy Wall Street movement, believe that they are not being listened to, that vested interests hold an improper, behind-the-scenes sway in the political life of our country. At the time when the country needs to pull together, the Supreme Court has chosen a path to magnify public cynicism. It is determined to protect moneyed influence peddling that obscures citizen speech and eviscerates the capacity of citizens and policymakers to weigh competing views in balanced ways. At issue, therefore, is whether a new analytical paradigm about the First Amendment, more consistent with linguistic logic, American history, and democratic values, is in order. Absent a clear directive from the Constitution, absent carefully expressed views of the founders, should not the courts follow a strict constructionist approach to the meaning of our individual rights-centered democracy? Rather than conflate a corporation with a person and money with speech, should not the focus be shifted to the transactional relationship inherent in speaking and listening? If all men are created equal, it follows that all citizens are entitled to have their views respectfully listened to in the public sphere, and after elections to have the representatives they choose be in a position to seek common ground in pursuit of the common good, unconstrained by having their ears plugged with corporate money. Historians are familiar with the saying, sometimes attributed to Bismarck, that the public should not look too closely at laws or sausages being made. Law and sausage making are different, but the commonality is public concern that the seen and unseen ingredients of each be integrated in as clean a manner as possible. Many good people enter politics only to find that the system causes the low road to become the one most traveled. Politicians routinely develop conflicts that do not technically rise to a legal standard of corruption because legislative law and now judicial fiat has weakened that standard. The low road is traveled because it is the shortest path to office and justified because other contenders generally stampede alongside, though increasingly far from the center stripe. If a candidate chooses a less conflicted route where few travel, the likelihood is that candidate will come up short. Speech is thus at issue from two perspectives. At one end, uncivil speech must be protected by the courts, but filtered by the public. At the other, moneyed speech must not be allowed to weaken the voices of the people. The Constitution begins, after all, we the people, not we the corporations. Here let me conclude with one observation and one challenge. The observation relates to how the subject of oath relates back to the subject of oaths. Before taking office, federal judges, unlike executive and legislative branch officials, must take two oaths. One is the same oath that the first two estates take. The second oath calls on judges to administer justice, doing equal right to the poor and to the rich. Very unusual phraseology. At the risk of presumption, it would seem reasonable to think that members of the judiciary might want to review, in the context of this oath, whether the court-made law in Citizens United empowers moneyed interests to the disadvantage of the unmoneyed or less moneyed. Finally, on the premise that lawyers have special obligations to express professional judgments on rule of the law questions, the challenge is to inquire if law schools and bar associations might find it appropriate to submit petitions or Friends of the Court briefs on citizenship issues like Citizens United, and likewise take stands before Congress on international rule of law issues such as the wisdom of ratifying the Law of the Sea Treaty, a comprehensive test ban, and various human rights treaties. Is it not likely that the most important pro bono work the legal profession can provide our country is to offer judgment on the key rule of law issues of the day? Lawyers are officers of the court. They're also citizens. Thank you.